The world will not be destroyed by those who do evil, but by those who watch them without doing anything. I'm Jessica Denson, and this is Lights On. Those were the words of Albert Einstein, an actual stable genius, really encapsulating the moment we find ourselves in, where it is incumbent upon the good faith, self-professed defenders of the rule of law and the Constitution to stand up in this moment, to uphold their oaths, to not allow a man who remains constitutionally disqualified from holding office from assuming that office. On Lights On, I have been reiterating and hounding this point of Section 3 of the 14th Amendment. It states that someone who is an insurrectionist cannot take the oath, and that disability cannot be removed without amnesty that is granted by a 2/3 vote of both houses of Congress. Once again, in this episode today, as I have been doing continuously on Lights On, we are going to reiterate why that insurrectionist status of Donald J. Trump remains. It was not mitigated or removed by the decision in Trump v. Anderson. That a decision applied only to his ballot access. So if there is any question on that whatsoever, we will clear that up once again. I'm going to be joined in just a moment by a constitutional scholar, the author of the original meaning of the 14th Amendment. He has clarity on this issue that is desperately needing to be heard by our lawmakers right now, in particular, our Democratic lawmakers who have been so clear on the issue of Donald Trump's status as an insurrectionist and why it is so vital to not abandon that and not abandon our Constitution in this moment. So please join me in welcoming to Lights On Associate Professor of Constitutional Law at Northern Illinois University, Evan Bernick. Evan, welcome to Lights On.
Thank you, Jessica. I wish I could say that I was pleased to be here, but under the current circumstances, I feel like that would be out of whack. But we'll do the best we can.
Okay, Evan, I just want to have your thoughts off the bat on where we stand with a constitutionally disqualified individual about to be sworn in to the presidency.
Well, I think you've stated the situation and the problem that we're confronting very succinctly. We have somebody who is constitutionally disqualified for the nation's higher office about to assume that office. He is about to assume that office in a context where a number of those who opposed his candidacy made this argument that he was constitutionally disqualified. And we really now have to see whether those were just words or the legislators who took this position, who argued that the Section 3 of the 14th Amendment disqualifies Trump because he committed insurrection, are really prepared to act on that constitutional obligation that they perceive as oath-taking constitutionally appointed officials themselves.
Absolutely. And I want to specifically address, as I have been on Lights On, the steps that can be taken by these lawmakers. Before we do that, I just want to play a clip from my previous conversations after the election with both Noah Bookbinder, who is the president of CREW, Citizens for Responsibility and Ethics in Washington. This is, of course, the group that brought the challenge up through the Colorado Supreme Court and to the United States Supreme Court, and Harvard constitutional law professor Lawrence Tribe. There has been some question out there as to whether Donald Trump remains disqualified in light of Trump v. Anderson. And here are both of these individuals confirming that he is, in fact, disqualified.
It's really a kind of a remarkable place to find ourselves, not in a good sense of that word. We had a trial, and the Colorado Supreme Court found that Donald Trump incited insurrection as a matter of law, and that he was disqualified. Now, the U.S. Supreme Court came in and said that states are not empowered to remove someone from the ballot for violating this constitutional provision. But what they did not do, and what no one has done, is actually to say that Donald Trump wasn't an insurrectionist. That finding stands.
It is worth remembering that under the law as it stands, Donald Trump is not qualified to be president of the United States. not simply as a matter of character or because of the impeachments, though they didn't ultimately succeed in removing him or in disqualifying him, not only because of all of that, but because of the Constitution itself. I think we have to confront the fact that when he takes the oath, whether with his fingers crossed or otherwise, it will be something that the Constitution says he is not qualified to do.
And Evan, after these conversations I've had with Noah and Professor Tribe, I've been digging into the scholarship on Section 3. I know you're familiar with William Bowden, Michael Paulson, who really kind of jump-started the conversation on why Section 3 was not dead letter after 2021 and that insurrection. And they wrote, in the wake of Trump v. Anderson, just recently, they wrote, "The nation, having watched the Supreme Court sweep Section 3 under the rug, it may well be that nobody will dare to lift the rug up for a long time. But if that is what happens, we should have no illusions that that is what the opinion in Trump v. Anderson actually requires, let alone what the Constitution requires." Evan, there is in fact nothing preventing constitutional actors from demanding that Section 3 be abided by in this moment, is there?
No, I mean, I would put the point more strongly. Section 3, combined with state and federal officials' oath to follow the Constitution, obliges them to give effect to what they understand Section 3 to mean. Even if the court had specifically said that Trump wasn't disqualified, and certainly now that the Supreme Court has not said that he isn't disqualified. The Supreme Court's opinion in Trump v. Anderson does not say very much about the meaning of Section 3, except that states cannot enforce Section 3 by removing people whom have been adjudicated to have committed insurrection from the ballots. In fact, the court emphasized in Congress's court concerning what they want to do regarding a alleged, and in this case, adjudicated insurrectionist.
Absolutely, Evan. And not only is it incumbent upon them, but there are specific tools. There's a variety of avenues they could be pursuing at this moment. Now, one I have discussed recently is the proposition of bringing up an amnesty bill. Now, this is another point that is fundamental, but there's still so much confusion out there as to what Section 3 actually means and what it lays out. Section 3 says that if someone is an insurrectionist barred from office, that disability can be removed by a 2/3 vote of both houses. A lot of people get this upside down. They think that a 2/3 vote of both houses is required to confirm the disability. It's actually required to remove the disability, which is obviously a very high threshold to reach. And in understanding this, I had a show last week where I discussed a piece written by a columnist named Caitlin Bird called "King Trump is Not Inevitable." And she proposed what I thought was a brilliant plan to bring up an amnesty bill. Senate Democrats still have control of that body. A Democrat in the Senate could raise this amnesty bill and use that as a pathway to affirm that the disqualification exists, which it currently does. And without a 2/3 vote to remove that disability, it would affirm that his disability remains. Can you kind of give me your thoughts on that potential course of action?
So first of all, I'm glad you brought up the text of Section 3, which specifically provides that Congress can remove the disability imposed upon somebody who has committed insurrection from office. The very fact that that provision is in there suggests, as Bode and Paulson have argued, and I believe to be correct, that Section 3 is self-executing. If you are an insurrectionist, you are, even if nobody else does anything, and you committed insurrection while holding an office under the United States, you are disqualified from office. It is illegal for you to assume office again. The question is, okay, if that's the case, what do we do about it? What mechanisms exist to ensure that this unlawful result does not take place? And the bill itself would be, the amnesty bill would be unnecessary in order to establish that Trump had committed insurrection or not. That would be the case regardless, or it wouldn't be the case regardless of the bill. But it would alert people to the reality that we are about to have an ongoing constitutional violation on our hands and motivate action to prevent that from happening.
Well, that's precisely what I have been trying to do, is motivate action. I will tell you, Evan, I have felt like I might have seen some movement from some Democratic lawmakers, those lawmakers that you talked about at the top of this interview as having been so clear and unambiguous as to the fact that Donald Trump is an insurrectionist. I read a piece from Politico from just before the election where it talked about the lack of appetite from Democrats to push forward with this in light of their past statements. I'll read from it. It says House Democrats are this is a statement from Representative Jeffries in September, saying House Democrats are going to do everything necessary to protect our democracy, defend the transfer of power, and ensure that the winner of the presidential election is certified on January 6th without drama or consequences. Now, if I could humbly assert that the period that we are about to enter is going to be far from free of drama or consequences if we actually abandon our Constitution and allow a man who is constitutionally disqualified for having violated the will of the people. I mean, let's be clear about what insurrection means: for having incited deadly force to keep himself in power against the will of the American voters. That if we are just going to pass that Rubicon, the consequences are already going to be so dire. So to suggest that not taking the burden and the uncertainty and the uncomfortable moment that we're in and tackling it and dealing with it to avoid drama or consequences, in my opinion, is to say the least, to put it mildly, terribly short-sighted.
So, I mean, the most charitable construction that I can put on a sentiment like that is that even those Democrats that believe correctly that Donald Trump is constitutionally disqualified also think that challenging his constitutional qualifications at this point would be fruitless, if not counterproductive. They're worried not just about flouting the will of the people, although they're certainly framing it that way, but effectively preventing themselves from being in a place where they can challenge constitutional violations that are perpetrated by a president whose very ascendance is itself unconstitutional. So they want to put themselves in a position to be part of a resistance to constitutional actions. And they're concerned that if they lead with an argument that's not going to work, that's not going to be accepted by the Supreme Court, that's going to make them look anti-democratic, although, as you point out, there's nothing anti-democratic about a constitutional rule that prevents people from trying to overthrow democracies from taking office. And so that's what they're concerned about. And the only thing that I can say to that is I hope there are at least a few of them that recognize that that's the cost-benefit analysis that they are making. They are saying to themselves, I know that something is unconstitutional, I know something about unconstitutional is about to happen. A walking, talking constitutional violation is about to enter office. And I am keeping my powder dry, and I am being prepared to oppose his unconstitutional actions once he takes office. But it's a dangerous game to acquiesce in what you think is an unconstitutional violation in the hopes that somewhere down the road, you'll be in a position to prevent further constitutional violations, because you can always say that to yourself. Well, not now. I'll bide my time. I'll wait for this. I'll wait for that. And then you habituate yourself to waiting. And then all of a sudden, you're looking to weather this administration and maybe defeat President Trump, who has decided that the text of the 12th Amendment, no less than the text of the Section 3 of the 14th Amendment, no longer binds him.
Yeah, I agree with you. It's a very, very foolish gamble, and it's a gamble that has no support from the all that we know about this man and how he operates, how he is planning on just steamrolling every law and norm that we have to try to pretend like you said, like they're keeping their powder dry because it's going to give them more chances to mitigate it, is to so many of us such a foolish and impractical calculation. And I got to tell you, Evan, there's so many people watching my show that agree so much with what you are saying, that agree so much with this conversation that I've been trying to shine a light and amplify, because we understand we cannot wait. The moment for action is now. We cannot wait. I want to just read one more thing from that Politico piece that I read from right before the election. It says, federal law gives Congress the power to challenge the validity of electors they deem not regularly given. And it adds that a federal appeals court recently opined that a candidate ineligible to hold office under the insurrection clause would be a valid basis for Congress to reject presidential electors in January. So other than that option that we talked about of just bringing this amnesty bill to raise the conversation, which is not necessary. It's not even necessary because his current status is disqualified. You and I were talking before we hit record about the technical process that could happen on January 6th. Can you explain a little bit of that, about how objections could be raised and the threshold for raising such objections?
Right. So even if the amnesty bill is introduced, quite frankly, it's not going to pass both houses of Congress, and it's not going to be signed into law. So you would still have this problem of how to prevent Donald Trump from taking office. And then you would still have to think about the Electoral Count Act and the process that it sets up for challenging the qualifications of a president who seems to have gotten the most electoral votes. And what it takes is first 1/5 of both houses of Congress to raise an objection, and then a majority of both houses of Congress to sustain that objection. Now, the precise contours of what kinds of objections would be enough to justify not allowing somebody to take office. This is not an area that has been extensively litigated, to say the least. But I just want to stress that from the perspective of Section 3, it's not as if there is a right on the part of somebody who has committed insurrection against the United States while holding an office under the United States to assume office, that then puts the presumption on people who are challenging it, any more than there's a right on the part of somebody who is 34 years old of age to assume the office of the presidency if he gets enough electoral votes in his favor that puts the burden on the challengers to establish that that person is not qualified. The requirement that one not be somebody who has committed insurrection while holding an office under the United States is no less part of the Constitution, no less basic to whether you can assume the presidency than the requirement that you be 35 years of age.
Absolutely. It's just straightforward, and it is there to be abided by. And if we abandon it now, for God's sakes, all bets are off. Evan, thank you so much for your time today and your clarity on this issue. I really appreciate it. I know our Lights On viewers appreciate it so much.
Thank you, Jessica.
My pleasure. My pleasure. And just as a reminder, in my previous episodes of Lights On, we've given specific tools as to how to contact your representatives, either through the Senate to force something like an amnesty bill just to raise this issue, or just to urge them to do their constitutional duty on January 6th. I will put links in the description to this video to both of those previous videos so that you can see the instructions for contacting Congress and urging them to uphold their constitutional duty, their oath to defend our Constitution against enemies, foreign and domestic, and for God's sakes, to do it now. Thank you, everybody, so much for joining me on Lights On. The best way to support my independent broadcasts is to subscribe to the Jessica Denson YouTube channel, which you're watching right now, and also to like and share this video, amplify this conversation that I know is not being had in many places, if anywhere else. So please do that. If you want to support my work specifically, you can do it at thejessicadenson.com. jessicadenson.com/donate. Thank you so much, everybody, for joining me today. And as always, let your light shine.